Okay, so I think we should start, and I just think that we need to try to solve all the confusions left by the previous panel on this one. So no big challenges here. Okay, so good morning and thank you very much, and welcome to the second panel of the day. I am Mario Romao. I work for Intel. I'm one of the directors dealing with policy, health, data, and I also touch on AI, which was already mentioned here today. And it's a pleasure to welcome you, and it's a pleasure to welcome all the panelists. I feel so humble alongside this expertise here. And this panel will touch about and will discuss about HIPAA, the privacy rule, and other things that you might want to address regarding basically the use of protected health information for research. And as well looking a bit into the future on what this might mean, while obviously keeping privacy, which is always the concern. It was also pinpointed on the previous panel. And actually, Professor Rein already mentioned something that I was mentioned, but I will do it again. When I look back in 15 years, right, 15 years back, 2003, was actually the official date for the end of the Human Genome Project, was 2003. And it was perhaps the yardstick that in medicine started what we call today big data. And this expression was not even coined then. It was coined later on. Much less artificial intelligence and machine learning was discussed among, let's say, many of us. They were just, in the settings regarding computer scientists and so on and so forth. So this means that a lot of things have changed. And I imagine that at least one obvious pressure point is this minimum necessary standards regarding the use of health data versus all these new technologies that really requires lots of data to perform well. So there is always a tension here as well. Another point that was mentioned that also didn't exist, well, actually 2003, the iPhone didn't exist then. It's amazing, right? The iPhone didn't exist. So all this consumer electronics era with smartwatches and so on and so forth that are really bringing a lot of more personal data. Many of our personal data that is basically always with us, that is also important when it's of good quality and meaningful for research. And the previous panel also mentioned in many instances they are not covered by HIPAA, so are covered eventually by other types of regulations. So the scenario has really changed a lot since 2003 in many aspects. But still, I believe some truths or some imperatives are there. One is the need to ensure that research and good research is being done and can be carried out. And the second one, to ensure also the privacy of the citizens and of the patients. And I guess it all hinges here. And to discuss this and other topics, I welcome my distinguished panel, which I would briefly introduce each one of you. And I won't read its amazing bios, but I will just be a summary, otherwise we will be over with the time. So Maya Bernstein, here, Senior Advisor of Privacy Policies of the Health and Human Services. Maya is a Senior Advisor for Privacy Policy in the Office of the Secretary of the Department of Health and Human Services. Her work includes policy development across the breadth of HHS activities such as health IT, human subject research, social welfare, cybersecurity, sharing of administrative data, insider threats, and personal privacy. Maya began her career at the Office of Management and Budget, where she was the lead on the Federal Privacy Act and privacy policy more generally for 9 years. And I will stop here for the moment. Thank you very much, Maya. Welcome. Kirk Nahra is partner from Wiley Rein. Kirk is partner in the DC office practice, where he specializes in privacy and information security, litigation and counseling, along with a variety of healthcare and compliance issues. He is the chair of the firm's privacy practice and co-chair of its healthcare practice. He assists companies in a wide range of industries in analyzing and implementing the requirements of privacy and security laws across the country and international. Thank you very much, Kirk, for joining us. And Kim Gray, thank you, Kim, for joining us. Kim is Chief Privacy Officer of IQVIA, and I pronounce it
IQVIA.
right.
That's right.
I trained before you. She's responsible for the company's privacy and data protection strategy. Kimberly serves on the Executive Council of iTrust, the Advisory Board of the Future of Privacy Forum, the Governing Board of the Philadelphia CISO Association, the Center for Information Policy Leadership, the Ethics Committee of the European Pharmaceutical Market Research Association, and the Confidentiality Coalition of the Healthcare Leadership Council. And I will stop here because there are more things to say. Again, thank you very much. I will perhaps kick off by asking Maya to give us a bit of a level set of the state of the art, the state of things as we are now. If you want to focus more on the research, please do, but if you want to go other areas as well, please.
Okay, thank you so much, and thank you to FPF and Duke for hosting us. I'm glad to be here this morning. I am required to tell you that I am not speaking for HHS or the secretary or the administration or my office or any of those people. These are my own thoughts. But yeah, it's my job to do a little level setting. I guess another little piece I will add about my bio is that when I was at the Office of Management and Budget in the 90s, it's the time that we were developing Secretary Shalala's legislation around HIPAA, and there was a privacy proposal which did not become law, and I continued to be there during the time that we produced a regulation. Actually, I was sitting with the Department of HHS and with Marcy and other people who were there at the time, producing the first draft of what did become the regulation. I do not work in the Office for Civil Rights, so I am not speaking from that perspective, but let me do just a little bit of level setting. The HIPAA privacy rule is like many other privacy rules in that in terms of access and disclosure, it has a basic structure, which is you can't disclose unless you have consent, and then there are a bunch of long exceptions, and some of those relate to research. So I think of those exceptions in four or five, depending on how you count them, categories. Most people focus on only a few of those, but there really are 4 or 5 categories in which you can access information for the purpose of doing research. One of them is to get consent, and as we heard on the last panel, sometimes that actually works. Sometimes that works for whatever your application is or your particular set of research, and you can go and get the actual consent of the subject of your data, but that doesn't work all the time. Sometimes it's administratively burdensome, or there's too many people, the people are deceased, whatever it is, you don't know who they are exactly. So the second way is to get de-identified data. And we touched on this a little bit in the last panel, but there are basically 2 ways to get de-identified data. One is to remove, I think this is the thing that people know and sort of maybe dislike a lot about the rule, you remove certain 18 direct and indirect identifiers, everything from people's names and account numbers and so forth that are direct identifiers to things like zip codes, other things that might lead you to be able to identify someone. And also, there's an added provision that says, plus anything else that you might know that will identify people, right? So there's this catch-all thing. And that can be very difficult. It means that you have to remove a lot of the interesting part of the data, and maybe it's not so useful for your application by the time that you do that. However, there are many companies and applications for which that works. I mean, IQVIA actually uses a ton of data, which they get that way, and obviously has a very successful business doing that. My own department is buying up lots of their data, actually, and using their very high-quality data to do things like recent drug pricing policy and so forth. The president made a recent announcement about, and we're using that type of data. But the second way to de-identify is to get an expert to say that there's a small chance that the data are identifiable or re-identifiable. But that small chance is not defined. What does it mean to be that small chance? There's the kind of expert you need is sort of only vaguely defined. There are no standards for how we know when they're de-identified exactly, right? That this expert can use. We're relying on their expertise. And not that many people have the kind of expertise that you want to either be able to hire or buy, so that you can find someone who will consult with you and tell you whether your data is de-identified to a point where there's a small risk of re-identification. So that can be, in the current day, pretty complicated and difficult and expensive, and not clear how successful. And I think because the standards aren't, there is guidance, but I think the standards, because the standards in the rule itself were not really laid out, then it can cause uncertainty, and most people who are doing research don't like uncertainty about whether they have proper access to the data. So that can cause some problems. A fourth way, which is probably the most popular way that people get access to data for research, is the provision that's also broken into two parts, which is to have a HIPAA Privacy Board review your proposal for research and waive the requirement for consent, that basic premise, that consent from people. And a HIPAA Privacy Board, again, is not that well defined. I am helping another agency to create one at the moment, and it doesn't say how many people have to be on it. It says that they have to have certain, have to have relevant expertise to the kind of decision they'll be making, but it doesn't really specify what that means. It does say that the people who serve on this board have to be, they have to, agree. So given that it doesn't say how many people have to be on board, does that mean you need only 2 people? If the 2 people agree, that's good. If they don't agree, you need a 3rd person. So let's say the minimum number is 3 people, at least one of whom has to not be a party to the transaction. They can't be the custodian of the data. They can't be the researcher obtaining the data. They can't have a conflict of interest, so maybe they can't be the subject of the data within reason. I mean, if you're looking at all Medicare data, you might want to have somebody over 65. That might be okay. If you're looking at, well, you can imagine a very large data set where it's likely somebody is, say, I don't know, if the covered entity is a very large insurer like Blue Cross or something like that, many people are covered by that. Maybe you have to find someone whose insurance company isn't Blue Cross, not sure, right? So these are some kind of questions, but the process also by which they have to decide is not particularly well defined. Whether they have to have a charter is not defined, but probably they do, right? So, you have to at least, I guess, pass the smell test, right? You have to have something reasonable, something that we will find reasonable, and if you're doing something in good conscience, it's probably reasonable, that's fine. But it's not very well defined. And so the alternative, which many people have, is to substitute for a HIPAA Privacy Board an institutional review board. If you're an entity that has your own IRB or has access to an IRB or can buy the services of an IRB, you may use that IRB to substitute, and if they review a proposal and agree that it's appropriate to disclose the data without the subject's consent, you can also access data that way. An IRB has more complicated rules, but many entities already have them and have them set up, and so it may be another way that entities can get access to data. So there's quite a lot of different ways to do this. It's not necessarily particularly burdensome, although it's not particularly sure and well laid out in some cases. So, I mean, I've talked for a little while. Maybe I should just stop there for the moment and just set that stage and allow you guys to fill in some of the more interesting things that are happening nowadays.
Okay.
Thank you.
Thank you, and actually, that's what I was about to say.
Oh,
Which is great. Kim, what's the state of things according to your view?
Okay, so I have a couple of thoughts about, I generally like HIPAA. Let me start by saying that I spent 11 years as the privacy officer for a health insurance company, so I lived it, breathed it, could speak it in my sleep backwards. It's not that I don't have much experience with it. At my current role, we are a human data science company. And so we are doing many things with data. We are using, as Maya said, a lot of de-identified data to do healthcare research. We are also a CRO. We do outsourced clinical research, which of course makes use of some identifiable data, which is generally outside of the purview of HIPAA in both of those cases. So the de-identified data is getting us outside of HIPAA, and then the research in itself is outside of HIPAA generally. So what I see as HIPAA 15 years later is not so much changes to HIPAA, but it's changes to the many things around HIPAA that are co-influencers, if you will. And one of the things I found interesting was, and as Maya was talking about setting up a privacy board, which is anticipated under the HIPAA Privacy Rule, she said that sometimes in lieu of a privacy board, people will make use of an IRB. And it caught me a little bit when you said it that way, Maya, because at my former position with the Blue Cross Blue Shield plan, we had a privacy board in place. Dutifully created it, named the people, figured out how it was going to work, and we never once used it. Because it turned out, I think the entire industry went to the IRB as first. And in lieu of an IRB, if you don't have access to one of them, well, then you create a privacy board. And I think that's really interesting because one of my gripes, if you will, is that IRBs are now opining on privacy. They were not created to opine on privacy. They were created for clinical research so that, they were looking at the ethics and the safety of things that were happening to people's bodies. But yet we have them functioning in a role right now where they're making decisions about privacy, about data use later. They're inconsistent. So if you're using an IRB from a major institution in Boston that takes a look at things and says, don't need to get consent here, we're going to grant a waiver of consent in this case, no patient consent needed. You could have the same set of facts and take it to a West Coast institution. I'm picking these. I'm not really I'm not really alluding to anything right now, okay? But pick another institution, another IRB. You could put the same facts before them and get a completely different answer about that. So there's no real guidance for the IRBs. It's very subjective. They're doing what they want to do. Some are erring on the side of caution, and some are way more lenient. And I think those in the industry doing research know where they're going to get the rubber stamp that's easy or the one that's a little more difficult, because frankly, those folks sitting on the board, that's not what they were here for. Privacy is not their area of expertise. They want to do the research. They want the good results. They want to advance healthcare. So that's my first place where I see we could do some improvement. Maybe the answer is relying more on privacy boards, but turning an industry that's so reliant today on IRBs into that direction is going to be a very difficult culture shift. So maybe it's more around, let's have some consistent standards around IRBs. Maybe we actually give guidance as to how they must do a decision-making process if, in fact, they're going to be in the business of dabbling in privacy. Closely related to that, I have a concern right now about informed consents. So there's a lot of disparity of viewpoint right now on what happens with an informed consent. And it's because informed consents, much like IRBs were for clinical trials, informed consents are what? Informed consents to participate in a trial. You're granting someone approval to use your body with their test medicine or their test medical device or whatever it is, and monitor how things are going to see if a particular modality, a particular therapy is going to be useful for other patients in the future. Right now, however, we have HIPAA and the Common Rule not really aligned on how that works. Throw in our brothers and sisters across the pond right now, the Europeans, and not having agreement on how an informed consent should work. And what I mean by that is you've got an informed consent for the trial, also capturing that data use. So again, it was made for the trial, but we're relying on that informed consent for what we're going to do with the data subsequently. So, two models are starting to emerge, one where you have two documents, the informed consent, which is really for the trial, and then a second consent or authorization, if you will, for what happens with your data and secondary uses of data later. Or you have a model that's emerging in Europe where consent is not part of the process at all. In fact, you use another legal basis for processing the data. And that other legal basis could be what we like to call legitimate interest or public interest, or the research exception, and this is anticipated under GDPR, But the difficulty is there's no agreement right now. And so you have the pharmaceutical companies and the device manufacturers not sure what they should be doing about these informed consents. You have the data protection authorities and the legislators in the various member states not sure whether consent is required or some other legal basis. And then you have ethics boards, which are the European equivalent-ish of our IRBs here, again, not in agreement. So if you are a multinational and you're having to comply with HIPAA and the Common Rule, and then every single member state where you're doing clinical trials in Europe and the ethics boards over there at the same time, it's a really difficult thing. Personally, I think consent had its day. I think consent for a trial is perfectly appropriate. Get that completely, truly informed consent for doing things with your body. I think that consent for data use isn't particularly relevant anymore, and there should be some alternatives in place. Which brings me back to my last point, which is under HIPAA, you can do all kinds of things with someone's data without getting their consent. You know, Maya mentioned you'd use consent, but then there's this gigantic list of exceptions. I almost see it the other way. There's a gigantic list of exceptions, and then, by the way, if they don't work, then you have to get consent. But in any case, much like I was just talking about these other legal bases for doing the processing of data that they're talking about in Europe, we've got this whole thing of TPO. So anybody who works in the HIPAA world knows that for treatment, payment, and healthcare operations, TPO, you can do all kinds of things with someone's data because it's expected to be part of what happens to make the healthcare wheels go around. It seems to me that research sits off by itself, kind of outside of all of that, and if research were actually treated in much the same way as treatment, payment, healthcare operations, we would have a better ability to have the flow of data needed. Putting aside, yes, a lot of the data is still not going to happen because of that confidential proprietary nature of the data we heard about in the beginning of this discussion, because that is for real. There are companies that don't want to share data for that reason. But for those who are willing to partake and to share, I think it would be helpful if we actually treated some of the research much like we treat TPO, with a huge caveat, however, which is never seems discussed, which is those organizations that are right now involved in treatment, payment, healthcare operations, the covered entities, the business associates, have to abide by HIPAA. They have administrative, technical, physical safeguards, all those kinds of things they have to put in place. They have to generally apply or respond to both the HIPAA Privacy Rule and the HIPAA Security Rule. And we haven't talked so much about if we were to move research into that same community, we're going to have to do the same thing with the researchers. Because right now, I can tell you, half of my company does research. They're really good at what they do. Do they understand privacy enough? Do they have the protections? Yes, we as a company do. Do the individuals always working in it always have that grasp? No, they don't. And I know that a lot of researchers who are not having the benefit of a large company with a privacy program that's monitoring and all that. Some researchers out there doing things on their own are not necessarily protecting our data the way we would want them to do so. So if we're going to open that up a little bit, then we should also have the requirement that they abide by HIPAA.
Yep. So let me jump in on a couple things. So I agree with what Kim said about the HIPAA Privacy Rule. I was surprised how negative the last panel was about the Privacy Rule. I think it's actually been a really good rule. I have been impressed over time as the industry has changed so much and the technology has changed so much at how many of the things that we see now that we didn't think were going to happen or weren't aware they're going to happen were actually anticipated very well by the Privacy Rule. The de-identification standard is something that lives in a different way over time. It evolves over time. The security rule evolves over time. And so I think there's lots of that very useful provisions in the Privacy Rule. But that's a regulation. I think the law, where Congress has gotten involved, has been much less effective. We heard discussion about portability in the last panel. I would spin it a little differently. I don't think the Privacy Rule is designed to support portability in any way, Privacy Rule is an offshoot of the fact that they agreed on portability, and Congress didn't have any idea what to do with privacy. I'm always amazed when people say, oh, people have been complying with the HIPAA privacy standards since 1996. Well, there are no HIPAA privacy standards in the HIPAA statute. It doesn't say anything about privacy. So what we're stuck with, and we've always known we were stuck with, is the jurisdictional scope of the HIPAA statute, which is what Congress did. Congress then gets involved in high tech, and they have this great idea of giving people incentives, economic incentives to implement electronic health records, but at the same time they say, well, if we're going to give them incentives, let's impose a whole bunch of extra obligations on them, and then while we're at it, let's make sure most of those obligations actually have nothing to do with electronic health records. So Congress's history is not very good on this. Congress, Marcy alluded to this, Congress took the HIPAA accounting rule, which is part of the privacy rule, which I agree didn't work. Congress made it worse. And then the one time I've not liked what HHS did, they made the accounting rule proposal way, way, way worse. And so maybe we'll get rid of that. But my conclusion is that the statute hasn't been very good and Congress hasn't been very good. I think the regulations have been pretty good. With that said, I think that one of the challenges we have in healthcare, and you're hearing it in lots of different places in these presentations, is the set of balances or issues and considerations we have to balance in healthcare, I think, is broader than anywhere else in our ecosystem. When we think about what kind of privacy restrictions are going to be imposed on the gap, we don't really care about public policy that much. We don't care about the interests of the citizenry at large. There's a couple of issues, but we don't have a broader perspective on that. In the healthcare space, we have all kinds of broader perspective, and I think research really drives that home, where the purpose of research is to serve the public at large for the most part. And that's just an interest, again, we don't care about very much with the gap. The ability to do research on whether people really want skinny jeans is not of that much public importance. And so that's part of the discussion that we have here. At the same time, I think that one of the things we're stuck with in HIPAA because of the scope of the statute is that all of these areas, mobile apps being obviously a good example from the last panel, but there's all kinds of health data being generated now, which is outside of HIPAA because it's not within the scope of covered entities. We can't, you can't change the privacy rule to deal with that because that's information that's just fundamentally outside of what Congress said the scope was. And so I think that we do have a real challenge in addressing those, what I call non-HIPAA health data, because it's largely not regulated. It's not regulated by the HIPAA rules. So that's some backdrop. Let me get into a couple of particular points. I think that most of the challenges with health information and research right now are more likely to be caused by the common rule than by HIPAA at this point. I agree with what Kim said. The common rule was great. If somebody's going to stick a drug in your body, you should know what might happen to you. Totally get that. I think the idea of...
Does everyone know what the common rule is? It's on human subjects protection, right?
So and
thank you.
That's out there. That's for there's obviously lots of appropriate purposes for that. I don't think data research should be subject to those same kinds of ideas. And you heard from the introductory presentation about how much big data. Most of that is just looking at data. We're not sticking anything in your body, and so it's a different set of issues. So I would like to see data research pulled out of the common rule at some level, but that's a change to the common rule, not a change to HIPAA. Within HIPAA, let me mention a couple of little points, but again, I think these are largely details. I think the research parts of HIPAA generally work pretty well. I think, as Kim said, there's inconsistency in how IRBs act. I think lots of people who are going to IRBs to make presentations are not good salespeople at their mission, and I think we could do a better job on that. Maybe that's education, et cetera. But a couple of points. There's some confusion in the privacy rule on the line between research and healthcare operations. If I am the Cleveland Clinic, and I love the Cleveland Clinic, but I'm using an example because everyone knows who they are. If the Cleveland Clinic wants to say, we're huge, we have tons of operations, we want to do an internal project to figure out if my high school buddy who's the top heart surgeon there is doing a great job on heart surgery, we can do that. We have enough data to do that. And that's healthcare operations. We have assumed consent. We don't need any permission for the patient. But there's a point in time where if they went into that and said, let's do something that we can publish in an important study so other people can learn from our experience, there's a line where that transitions to research under the rules and the rules change. I don't think that's a good idea. I think that's a problem, although I frankly think that companies could be more assertive about doing quality reviews, and if there's something useful there, they can then publish it. But that's one piece. There are provisions in the HIPAA Privacy Rule for waiver of patient authorization, and there are standards there. I would like to see those standards be rewritten. I don't think they address the right kinds of issues, and I think you could make it easier to get either an IRB or a privacy review board to waive authorizations. I'd like to see some more flexibility built into those standards. The other place where I think we need more flexibility from the healthcare providers, or more ability of the healthcare providers to participate, and this again is something that linked to the earlier presentation, which is particularly as we think about personalized medicine, there is more need to go out and find patients to participate in research. You don't have a mass population. It's not a question of, oh, there's 50 million people that have high cholesterol. We don't have any problem finding people with high cholesterol. We're now needing to look for people with very particular kinds of things, and I think the rules do make it a little harder to find those people. I'd like to see more flexibility to simply find those people. That doesn't mean you're going to say, oh, we found you, now you're stuck in this research trial. We're going to go back to inform, we're going to do all those things. But I think the HIPAA Privacy Rule, even though there are provisions for dealing with in anticipation of research, I would like to see more of that. I'd like to see more opportunity, and I think that's particularly going to be important as we drill down into personalized medicine, where there's a beneficial mutual interest of the society at large and these patients who are out there and might be very interested in participating in this research, but we have trouble finding them. So those are a couple of particular provisions that I think could be modified. But again, I think that the HIPAA rules generally work pretty well on research. I think there was a little bit of a missed opportunity when there were some changes to the common rule recently. I think they moved closer to HIPAA. They didn't move all the way to HIPAA. I would have liked to see that. And I would like to see a broader evaluation, although I have no confidence that this is going to happen, a broader evaluation of taking pure data research outside of the scope of what's covered by the common rule.
Thank you very much. Any immediate reaction? I
So
think
one thing that occurred to me while you guys were talking is just about what's research, right? So the common rule, HIPAA, even so from a federal agency point of view, there are many research agencies which are statistical agencies that want to have access to medical records. There are federal entities that are covered by HIPAA. CMS is, Medicare, Medicaid covered by HIPAA. Indian Health Service is covered by HIPAA, the VA is covered by HIPAA, Defense, and so forth, who are providing health services with big populations. And so they also have a different definition of what exactly is research, and those aren't very well aligned. And I think Kirk also alluded to the fact that that's one of the problems that we have is how do you know if what you're doing is research? Not just even within the HIPAA rule, but also across the different kinds of authorities that major research entities are dealing with.
I mean, I think HIPAA basically says if you're doing it for yourself, it's operations. If you're doing it for the public interest or a broader dissemination, it's research, which is just counterproductive. I mean, the idea that I could go into my patient records and do an analysis of, how many people had to return to the hospital, whatever it is, and I learned something from that, and all of a sudden, if I want to publish that, I've already used the data. I've already done the analysis. The idea that I now have to follow a new set of rules is bizarre. Now, I could figure out ways within the structure of the HIPAA rules to not do it that way. I mean, they talk about sort of going in with a mission. If I learn something for my own internal purposes and it turns out there's something that other people might be interested in, I can justify that, I think, under the HIPAA rules. But if my goal is to go in from scratch and do that analysis with the idea of helping others, HIPAA says I can't do that unless I meet the research rules, and I don't really understand that. I mean, the use of the data is exactly the same. Now, as Kim pointed out, you may not want to say, oh, I'm going to hand it out to some external researcher, and they're not going to have any controls because they're not a business associate, they're not subject to it. But we absolutely have to deal with that issue, and that's That's one reason why there was actually a legislative proposal that was, I think it was part of the 21st Century Cures Act in the House version, didn't get in the final law, where they were just going to add the word research to healthcare operations. I actually thought that was going to be a problem because that would mean that a covered entity could disclose to anyone they wanted information for research purposes, which would have a whole lot of information be disclosed to whoever I gave it to with no requirements imposed on the recipient of that data. So I didn't like that solution, but the idea of making it easier for people to use their own data in particular to do analytics, even if that analytics is broadly disseminated, I would certainly encourage that.
Yeah, just one other quick thing to jump in. I think Maya's question is a good one. What is research? Not only the HIPAA definition that Kirk's talking about, that distinction between when it's generalizable knowledge or not, but in today's world, we're doing less and less of the pure clinical trials and more of the real-world evidence, retrospective reviews that may or may not use identifiable data, de-identified data, somewhere on that whole continuum. But what happens to a patient out there in the wild, not in the controlled setting, but in their real life? How we're looking at how therapies work for that. That particular kind of research is expanding greatly at this point of time.
Let me just jump in on one other point, which is connected to that, which is the de-identification idea. I think the de-identification rule remains a good rule because it evolves with time. I was a little surprised in the last panel talking about how it's vague and confused. I think it's a pretty good rule, and I think it's actually the best rule that exists on de-identification at this point. One point that I could see being added to that provision or being a slightly more important component of that is that I think you do need to factor context into what's happening with information. If I have a data set and I've done a bunch of steps to remove identifiers, if I'm going to post it on the internet, I have to have a really strong de-identification standard. I get that. But if I'm going to provide a data set to a researcher to do some kind of data analytics, I'm less concerned about what might go wrong with that. I'm not unconcerned. I'm just less concerned. And so I could see a varying standard that's more explicit based on context. And I think in some situations it might be useful, and this has been floated as an idea in legislation. I don't know if it would have to be legislation or we could think about a way to get into the rule. But you could also factor that context into an agreement by the recipient not to re-identify. I think that there's lots of concerns about, well, could they re-identify? Yeah, again, if I post it on the internet, anybody in the world might try to figure out what it is. But if I'm giving it to a researcher and they don't actually care who the person is and they agree not to re-identify, it seems to me that's a relevant component on identifying risk where you're focused on, again, the public benefit from this research, and there really isn't a material privacy risk there because they're not going to try to figure out. It doesn't matter to their research who that person is. I think that's that might be a useful added element.
And that's something that's being done generally anyway. So those experts who are looking at whether something is de-identified enough, if you will, are looking at context, they're looking at recipients, trustworthiness, they're looking at those controls you put in place, they're looking for contract, they're looking for all of that when they're making the determination if this particular data set is de-identified or it's not de-identified. So taking that a step further and maybe making something a little more formal, I think a lot of us in industry would support. We do it anyway. We have some guidance out there that suggests that kind of thing. HITRUST created a DID framework. So there's guidance out there that's being used by that, and that, by the way, is being mirrored around the world too. It's, as you said, HIPAA's the best standard there is, in my opinion as well. Better certainly than anything else any other countries have going at this point, and it's being modeled as far as DID goes.
Yeah, I was going to add, we've been talking about how to make data more available, and to the extent that we're also concerned about protecting privacy while we're doing research, I have to say I don't like the word balance. That sort of seems to me that you get more of one and less of the other, but I like the idea that we can both disclose and with technology and expertise also get privacy, like a rising tide lifts all boats. I like that metaphor better. But just thinking about the places where we're doing research, they're not covered. I'm not making any suggestions that anything new should be covered, but just to think about what the world looks like now, we have there's an advisory committee to the Secretary called the National Committee on Vital and Health Statistics, which is an arcane name, but really is the Secretary's Committee on Health, IT, and HIPAA. and did a lot of work, 15, some more than that, years ago, on which we based a lot of the original rulemakings. But there are things that are just not in the scope because, as we talked about, as Kirk talked about, the scope of the law itself doesn't cover them. So we have, for example, disease registries. We have new kinds of technology that are coming out that are wired, that are medical devices, infusion pumps, or other kinds of places tons of places where we're collecting health information, as many of you know, or are the developers of, that may also be involved in research, or that we may want to use for research, and we haven't thought about sort of how that's protected. Even if we think about clinical trials, much of the work can be done in an environment that's not covered by HIPAA. It might be covered by something else, by the Common Rule, for example, which we talked about may or may not be a very good fit for privacy. And so it's interesting to think about all the new developments that we have with technology or big data when we compile together things like disease registries in an environment that's not HIPAA covered. Is that appropriate? Is that what we should be doing? Are there things we could do differently that would make both a better research environment and a better privacy environment for our patients? Or is maybe that a way that we should figure out how to use that data in a retrospective way that is more free for the purpose of advancing public health, advancing scientific knowledge, and so forth.
Well, let me jump in. I mean, I don't want to pick on the word balance. I don't care about that one or the other. But I mean, I think that you do have to factor in different perspectives. I'm not sure it's a zero-sum game, which balance may imply. And I think, for example, de-identification standards is a perfect example of that, where, again, if you go back to the original, I don't remember which version of the comments it was, but there was a very explicit discussion by HHS when they're coming up with the de-identification rule of basically saying, we could write this to say that you can only treat information as de-identified if there's a zero risk. We think that what that will do is it will create a very tiny additional value for privacy at the expense of all kinds of valuable uses of this information. And so that's why they came up with this very small risk element. They said the incremental benefits to privacy are way less than the positive benefits to society of using this information. And so research is a perfect example in that setting of where you really there's very little additional benefit to individuals, but a lot of potential benefits to society, which obviously includes those individuals. And so I think that kind of discussion of, again, different perspectives. And I think that you just have to factor in a much broader a variety of stakeholders in any discussion of healthcare, again, by comparing it to the Gap or comparing it to Facebook or comparing it to a bank, all of which have important stakeholders you need to think about. I just think there are more of them and the interrelationships are more complicated in healthcare, which is one reason why I think it's such an interesting field. And I think that as we start to think about a national privacy debate, I think there's a lot to be learned from HIPAA in that national privacy debate. I don't think the solution to the national privacy discussion is to say, let's broaden HIPAA so that everybody's a covered entity. That's not the right answer. But for example, Kim referenced the idea of treatment payment healthcare operations and the idea that essentially built into the HIPAA privacy rule. Again, this was something HHS wrote. I think this was a great idea. What they basically said was, we're going to write a law that essentially says this is what's normal in the healthcare setting, and we're just going to allow that to happen. And that's been a really successful part of the HIPAA privacy rule. It doesn't create meaningful privacy concerns from the broad array of the population. People know that their information is going to be used, to the extent they think about it at all, that's a different issue, but they know that their information is going to be used for treatment. They know it's going to be used for payment. We can mess around with healthcare operations a little bit, but you have to understand that people need to be able to run their business and do the normal kinds of things there. I think that concept, which we're seeing now in the national privacy debate, you hear a discussion about context or something else like that, I think that's a really good lesson to learn from HIPAA. We can, again, you may say we've learned some things that we don't like out of HIPAA, and I have no problem with that, but I think there's a lot to be learned from HIPAA just because it's the most evolved structure that we have at this point. And they've done, for the most part, a pretty good job of thinking about all these different audiences and all these different competing considerations. Again, not necessarily competing in a zero-sum game, but these different considerations that we have to think about in making this rule go forward.
Thank you very much. You have really been making this really easy for me because you really discuss amongst yourselves, which is fantastic. So thank you very much. I really appreciate it. And I was just throwing a couple of points there. The patient's perspective, let's say the individual's perspective, which we haven't discussed much yet. And there were a couple of things that I would like to hear your views. On the one hand, and thanks, Kim, for bringing the TPO, the treatment, payment, and operations forward. There seems to be kind of a, different scales of concerns indeed. So some kind of research, as long as it's internal, as Kirk said, it's allowed. So the patient does not need to authorize. But for other uses, so some people said it's okay. HIPAA treats research on the wider sense to create knowledge as an exception. Is an exceptionalism. So my first question is, by eventually broadening this concept of, okay, we can do research as long as, let's say, the risk to the patient's privacy is kept under control, instead of really depending it on the purpose, right? Operations, okay. Research, no, okay. So more on a risk-based versus purpose-based. Would it bring potentially, privacy advocates more concern, or like loosening a little bit the privacy controls? That's kind of one question. And the other one is on patient engagement. In many instances, we hear that we need to keep people engaged, so citizens engaged, knowing what their data is being used for, also benefiting from eventually results and findings to their own care, and basically informed patients are also those that potentially will be more inclined to, okay, that's fine, use my data, in spite of the fact that actually the surveys show that a large majority of the population is actually okay on sharing the data, with some caveats on commercial uses. But at the end of the day, everything tends to be commercial. So it's a hard one to draw a line. So my basic question is that, what do you feel the patient's reaction would be on, let's say, broadening so to speak, the waivers to use data on a TPO type of line? And are we doing, or is HIPAA doing enough, or is said enough about patient engagement, or it's not for HIPAA to do and that, or it's more for IQVIA, for instance, to get patient engagement, or others, hospitals and others, to take the lead on that one?
Do you want to start?
Sure. What HIPAA does for patients is basically say, again, define a normal, and it essentially says, we're just going to assume by law that you're on board with that as a patient. Now, if you sat down, I think HHS may have envisioned a little bit this mythology, which just has not turned out to be true, that you were going to go to the doctor, and the doctor was going to come into the office, and you were going to have a lovely conversation about the privacy notice. None of that happens. But the idea is, for the normal stuff, we're basically just going to assume patient consent. You can go a different direction on that. I get that. But at the same time, I think that's one of the reasons why the HIPAA rules work so well. And so, that's how we've treated patients. I'm not sure, we said we've drawn the line that says for most research, unless an IRB or privacy board says you don't need permission, you need to have patient permission. I agree that many patients in many settings will agree to give that permission. However, that doesn't, for example, help you find the patients. You already have to have a patient to go ask them for permission. And for some of these issues where, again, it's retrospective data analysis, and I need the data to be specific to a person, but I don't care who that person is, I'm not sure how much, it seems to me that's the trade-off on, and again, trade-off being bad, I think that's the trade-off on an individual privacy interest versus someone else. The other thing that I would like to see, and this is something we're seeing emerge a little bit in the debate now, is privacy advocates who are not just focused on an individual, but do have some broader sense of the societal benefit. I think that we've seen in the privacy debate, particularly in the healthcare field, most of the patient advocacy community has been very focused on particular situations and particular communities. I was involved in an organization a couple years ago trying to find this group. I would love to see a lobbying organization on privacy called Patients of America, who have the general view of the patient population at large, because I think most patients want healthcare to work, want it to be effective, want it to be less bothersome, want it to be less expensive. They want the system to work well, and we don't necessarily have that perspective in the debate right now, or it's at least not as loud a voice in the debate as I think it should be. And I think, again, because of all these balances, I don't need the Blue Jean Consumers of America Association, but I do think that having a group that would be largely reflective of the average person, recognizing all the complexities of that. But I mean, I think that would be a real useful benefit, and that would be a way to get a patient perspective that isn't a more highly sensitive patient population, which has really been the only part of the privacy debate at this point.
Any other comments before we open?
Yeah, I just was going to comment quickly. I think one of the things we're asked to be focused on research here, but I think it's important to recognize that HIPAA, there's a larger context in which all of these rules operate. And at the time of HIPAA, patients didn't have the right to access their own record, right? So this is a huge change that came along in terms of the relationship between patients and doctors, and obligations that now covered entities have to their patients to make their records available in a timely and not at a reasonable cost if there's a cost, and so that patients can find out what's going on. And for all the faults of the accounting for disclosures rule, which there are many faults, and it is potentially extremely expensive, and people have surely criticized it. But in terms of how privacy people and advocacy people think of privacy, it's one of the basic fair information principles that you should be able to find out what happened to your data. And that's what the accounting for disclosures rule would allow. It would allow you to see who's using your data for research, who's using your data for, not for TPO, but for most of those other disclosures. And it's true that it's not used very often, but when you want to use it, the reason you would want to use it is only when something goes wrong. That's when you need to find what happened out there, where things went, so that you can go and correct the problem. You expect it to be used rarely because the system's generally working. But I think that all those pieces were meant to work together to, it's not particularly inside TPO or inside the research protection, but taken all together, the context is partly to impose obligations on covered entities and to give rights to patients, and to help that relationship for that reason.
Yeah, just real quickly, I think from the patient's perspective, there is need to consider that, and I think there's need to educate. We had done a study a few years back looking at this very thing, and wondering, did a patient want their data to be used or not? And if they just think you're randomly using their data for whatever, no, they don't. When you explain to them the good that comes from it to the public health, you see the scale starting to tip. And then when you personalize it even more and they realize it could be their child or their spouse or something else, it tips it even more for them to understand. So I think a lot of it's education. I think the other thing is, though, and something that it's kind of part of my core, and so I tend to think everyone thinks this way, and my apologies, but you don't need any more data than you need. So consider the minimum necessary rule under HIPAA. If you can do this kind of thing by de-identifying or by doing something else where you're obfuscating some of the data, you may still need some of it to be able to do what we're talking about. But even under the European standard that I talked about, where I said, you're having a legitimate basis for processing other than consent, they also, under that same rule, require that you pseudonymize the data. So there is built in, back to your point, Maya, about there are pluses and minuses and safeguards and all that other kind of thing, but it's not just randomly giving every bit of gory detail about someone to a researcher. Quite the contrary, you give what they absolutely need, and then you show the patients the benefits of that, fruits of the labor.
Let me mention 2 quick points, I think, which tie into what Kim was saying. I think there are 2 big picture policy issues that cut across privacy but are going to be huge discussions going forward. One is the tension between this minimum necessary idea that Kim was talking about and the whole premise of big data, which is every time you read some study coming out of a big data analysis, they say these 3 factors were important to drive X. There was one that I use in my classes about marital status, income, and number of cars driving some kind of emergency room behavior, whatever. In order to figure that out, think how many data factors they had to look at that didn't matter. And so there's just this enormous tension between big data and this idea of data minimization. I think that's going to be a huge issue. The other issue is artificial intelligence and algorithms and the potential questions about discrimination, which are absolutely real questions. The question in my mind is whether we're going to address those issues through privacy law or through something else law. For the most part, historically, to the extent we've had those laws, they haven't been privacy laws. They've been a Civil Rights Act. They've been they've been a something else. I don't know the answer to that one. I think that's a big part of the question, though, is whether we're going to be able to dictate how this data ultimately can be used and decide whether that's going to be part of a privacy law. I always say in my classes that if we did we gathered all the data about everybody in this room to find out who's the perfect audience for the next time I want to do a HIPAA marketing session, and I want to go out and target some other population of people based on your information, real interesting question is whether that's a privacy issue at all. I'm using your data to go find other people, and I don't know whether we deal with that in privacy law. Again, I'm not saying we don't deal with that in privacy law, but I think a lot of the questions about discrimination have not historically been viewed necessarily as privacy issues, and I think things like algorithms and artificial intelligence are making that issue much more significant for us to try to figure out.
Agrees. Thank you very much. And there are a few questions, right? And okay, please.
You made... Oh, wow.
Hello.
Sorry, hi, by the way, I'm Guy. I work for a company called Privatar. We do de-identification, things like that. So I was interested in you saying that you saw the HIPAA de-identification rule as a great success and a kind of something that we should use to expand into other areas. What are the sort of criteria you see it as being successful on? What makes you think that?
So it sets up a governance, if you will. So it runs the suggestions of having particular experts, giving some kinds of examples of the types of background the experts should have who would opine on whether something has been de-identified or not. It allows some flexibility so that the data is still useful. You have different ways in which you can obfuscate the data. You can do, 10 different things to still have the data be useful, but have the data not be readily identifiable. I think the risk-based approach, where there is no such thing as zero risk in anything we do. So one of the things I find frustrating are those who look at anonymous data as having to have zero risk of identifiability. And that's ludicrous. Nothing has zero risk of anything. And I think HIPAA anticipated all those kinds of things when setting up the DID standard. I think that the guidance perhaps that's come out of it by organizations such as NIST and ISO and HITRUST and others who are trying to make it a little bit more understandable is probably a little bit better, and that's what's being shopped around, if you will, and discussed in other countries as part of the model. But there's a governance in place where you have somebody responsible for it. There's certain elements of that DID program that goes beyond. It's not merely a software application. It's considering all kinds of other environmental factors and other things, as Kirk was talking about. Who's your recipient? Are you posting it to the internet, or are you giving it to a trusted recipient? All those kinds of risk factors that are taken into effect when you're doing your determination that makes me think it's very well developed. I don't know if
Thank you. And next question, I believe. Thank you.
Excuse me. I just wanted to suggest that I have a partial solution, at least, to some of the transfer of information that has the potential to be re-identified. A couple of years ago, I published an article with a statute that would set up an opt-in framework whereby a data discloser and a data recipient would agree to comply with the framework, and the framework establishes standards and enforcement methods and a chain of custody so that as the data moves and that the prohibition against re-identifying data could be enforced by a data subject or an administrative agency or someone else involved in the contract, and that's the kind of solution that you described.
Yeah, no, I agree, and I think that idea of prohibiting re-identification has been something that there's a building consensus on that. I'm not exactly sure what the vehicle for that point to go into law is, but I think that, again, the industry who might resist other kinds of changes generally hasn't been resisting that kind of change because, as I said, they, for the most part, aren't interested in re-identifying.
I will allow one last question, which I will get great.
Thanks. Laura Hoffman, American Medical Association. Talking about research, obviously there's been press lately about Memorial Sloan Kettering and what they've done with some of their samples in terms of where profit is allowed when you use some of these samples for research. And my question is, under obviously the privacy rule, you can use information for research without a patient's authorization, but sale of PHI requires authorization. So where's the intersection there? What's the line? Where does patient consent come in? What do you think we'll be saying about this 15
Thank you.
years
We're
later?
out of time, so we'll have... I mean, the short answer is that, it's really, there's not an answer to that. I mean, there's going to be an answer in particular situations. But for the most part, the sale is only, I think, just to overgeneralize. Let me be clear that I'm overgeneralizing. Sale is only going to really happen where there's de-identified information. There may be there may be some limited contexts where people can use limited data sets or somewhat, mostly de-identified data in particular contexts where the only way that a company is going to be encouraged, maybe it's the proprietary point or whatever risk, whatever, they're going to say, well, we sort of know why we can do this, but we're not going to bother unless you give us some money. I could see that in very limited circumstances, but I think in general it's going to be de-identified information that's going to result in any kind of sale.
Thanks a lot, and I got a special request for the last question for Jody. If you can get a microphone so that everyone, and now.
Come on, you can shout, Jody. It's not that
I'll close the session.
Thank you very much. I appreciate the one additional question. So you talked about the distinction between healthcare operations and research. And I was wondering if you all have thought at all about where information is being used. There's a blurring of the line between healthcare operations, research, and also creating algorithms that could be used for commercialization of a product. So where there's some healthcare operation activity or some research activity, but either at least there is an intent to create a commercialized product, and I would love your thoughts on how that fits into the discussion about research and healthcare ops.
I'm happy.
We're out of time.
No, I'm happy to jump. No, but put it. I think that may be a somewhat easier question. I mean, I would look at that and say that if I'm a hospital, for example, and I want to use data that I have to build something that, again, is not going to reveal outside any PHI, but I'm going to build an algorithm. I don't see any real reasons I couldn't do that under HIPAA.
But what if it's outside?
Well, is it a business associate? I mean, again, if it's that would be where you get back to the line between research and business. If they're working for me, if I hire somebody to come in and help me, I'm a hospital. I'm not an algorithm builder. If I want to hire some firm to come in and help me build it, and I make them a business associate, I think that's straightforward. I think if you hire the University of wherever to come in and do, that, then you start to blur the line with research.
Did you mean commercially for the covered entity's own commercial, or an outside party who wants to develop?
Provider, they get some benefit from the use of this algorithm. There's a tech company that is developing something for the healthcare provider, but really 90% of what they're trying to do is develop a product that they're going to commercialize, and they're going to give it, they're going to make it available to this healthcare provider who's data readers and also. So it's a healthcare operation for the covered entity, but really the primary purpose of the business associate is to develop a commercial product and how.
I mean, again, if it's a sham business associate relationship, if they're not, that's a different, if what I'm doing, for example, if the technology vendor says, hi, I want to be your business associate, I want to do this, I will pay you to be your business associate. I mean, okay, that's going to be a red flag in my mind. I'm surprised how often I get questions about those kinds. It's like, no, the vendors don't pay the customer. It's supposed to work the other way. I'm not aware of anything in the rule that says it has to be differently, but if I'm OCR, I'm probably pretty skeptical of a relationship like that. So I think it's a question of whether, again, is it 90-10? Is it 50-50? Is it somebody who's hiring a legitimate, I'm hiring you to, I'm a actuarial firm. Take out of technology. I'm going to do actuarial work for you, and the data that I'm using for you is going to help me do actuarial work for other people in the future. I don't think that's a problem, actually. But I think that sort of assumes that the first step is a legitimate step that's done consistent with the rule.
And I think we need to leave this matter as it is. And thank you very much to the panel. It was fantastic. Thank you very much to the three of you. Thank you very much. Thank you very much. And try to keep on time. I'll ask David Hoffman, if you give us just 3 minutes for David Hoffman to do the...
Yeah, I'll just say some quick closing remarks.
Thank you, David Hoffman.
Thank you, Mario. Thank you to the panel again. Thank you very much. And so I do want to just say some words of thanks and to put this in context for some future conversations. So I'm David Hoffman. I'm the Global Privacy Officer at Intel Corporation. One of the things that has been one of the maxims of my career where I've seen great progress made is when you can bring together people from diverse areas who are brilliant in their field and have them collaborate together and exchange ideas. So I've had the great fortune of working at Intel, but also being a senior lecturing fellow at Duke Law School and also being on the advisory board of the Future of Privacy Forum. And for Duke being a leader in the provision of healthcare services and looking at the law and policy issues associated with healthcare, in particular Professor Rei's work, with the incredible job that the Future of Privacy Forum has done at looking out to where are the privacy issues that are going to be coming in the future with our advances of technology. And Intel's then move to really trying to figure out where is our data-centric society moving towards, and what are the roles that different technologies are going to play in that. This is the kind of conversation we really want to continue to make happen. So we've been looking at this for a while. We've been trying to write white papers. We have an initiative that we call Rethinking Privacy, where we were looking at traditional ways of doing privacy. Generally, we're using the Fair Information Practice principles, but also looking at traditional concepts like HIPAA and saying, what needs to be modified to this? And so what we found is that when we would go talk to stakeholders, particularly when we would talk to regulators and staff of legislators in various countries, they now have gotten to the point of saying, okay, that's great, we've read white papers, we've read a lot of commentary, but we really need to see specifics. We need to see specific changes of what you want to have modified in legislation and regulation. So we've moved in that direction. There's a big conversation going on right now in the United States around potentially the need for a comprehensive U.S. federal privacy law. Intel's had a position for over 15 years that we think a comprehensive privacy law is necessary. And so we finally, we've written several papers on that. We finally wrote a bill. And Chloe Audio, from our staff, who's here in the room today, actually worked to make sure there's a specific web application, and we posted our draft privacy law at usprivacybill.intel.com and solicited comments from experts, some of whom are in the room. Kirk was one of the experts who's been commenting, and also from the general public. We want to move more in that direction. We think, why are we doing public policy the same way we've done it for 40 years in rooms with, closed-door rooms where conversations are non-transparent, the public doesn't know what's going on, people don't really know what language is being discussed. That has a role in making sure that those private conversations happen. But there's got to be something where we use the technology innovations of the past decade, the past 2 decades, to actually get more people into the conversation and understand what trade-offs we're potentially making. So we're entering into that conversation right now. We're trying to figure out, as several of the panelists described, what's the overlap behind a comprehensive U.S. federal privacy law plus the regime that we already have in place for healthcare data, whether it's covered entities or non-covered entities. How do we manage that in the future if we're going to change HIPAA and or put a comprehensive law in place or enact a whole bunch of different state laws here in the United States? And then what does that mean outside the United States? So we wanted this to be a start, not an end to the conversation. Intel's going to look to keep bringing these organizations together, working with FPF, working with Duke, and trying to do things. And we hope that you'll join us in that as we do future events. So I want to say thank you to Duke and DC for hosting this. Thanks to Dr. Rai and to Duke Law School. Thanks to the Future of Privacy Forum, particularly Carson Martinez, who did a tremendous amount of work to pull this off. Thanks to our panelists, and thanks to all of you for participating. We have recorded this. We'll post it. Hopefully we'll let all of you know when that's posted, because we're going to use that as a record, isolate key issues, and continue the conversation. Thank you again.